I'm the Register of Probate. I oversee the Probate and Family Court for Worcester County, so all 60 cities and towns in Worcester County. And we handle different cases like divorces, child support, child custody, and then probating estates when someone passes away. I started giving a presentation out in the community a year or so ago about different ways to avoid the probate and family court and tips and tricks to work around the court, and teamed up with Katie, who is the Register of Deeds, because our offices overlap and we're both elected in the community and we both enjoy going out and trying to let people know about our offices and the different services that we can offer. And so we've now teamed up to put together this presentation for senior centers or other community groups to give you some ideas on ways to avoid the probate and family court and then the importance of your house and your deeds. So sure.
So thank you. I'm Katie Toomey. I'm the Register of Deeds. I'm on my winding down my 5th year as it's my first run at being Register of Deeds. What Stephanie failed to tell you is you get the benefit of 2 lawyers. We're both attorneys. I've practiced law. I started my career in the government public service a little later. I had a midlife crisis in my 40s and decided to run for office. So I have a little bit of a private practice background. I've been a lawyer for 24 years. I just like to pretend I look younger. That's why I hang out with Stephanie. It makes me feel younger. So, but anyway, Stephanie reached out to me a while back and said, you know, I'm doing this. I did a couple of these presentations and I'm getting a lot of questions about deeds, and it just kind of goes hand in hand. And we do have a lot of crossover. A lot of times people will literally come to the Registry of Deeds and say, here I have my documentation for the Registry of Probate. So you'll see that there's a lot of overlap. So we felt we could make time better for everybody to do this together, because your house is your largest asset, generally speaking, or if you own a building, a commercial building as an investment or anything like that, that it is something you're going to want to put into your estate plan and whether or not it needs to be probated. And so you have us as tools to kind of talk about that. So we bring broad strokes of ideas. We talk about things to kind of throw out topics. Please interrupt us. Please ask questions. Please ask for clarification. Please bring up stories. You'll hear us tell stories from things that come into us in our jobs at the registries. Honestly, when we have stories, it's usually the problems, but we all learn from problems, right? That's how I learn. So what not to do in the future, make a mental note. So you'll have some fun stories usually by the end of the hour that we're here. So that's what I have to offer.
Perfect. And with that, let's kick off some different ways to avoid the probate and family court. Generally, if you have an asset that's going to pass to another individual, so something that has a beneficiary, like your life insurance policy, or your a bank account that has another person's name on it, that's one way to avoid the probate court. So you avoid the probate court by having an asset that passes directly to somebody else upon death. If you do not have somebody else to pass that asset to, that is how you end up with us in the probate court. You have to probate the estate of someone who's passed away to have access to get those assets. And so we like to tell you to start thinking about the different documents you're going to want to put in place as part of your estate plan. So your wills, we'll get into trusts. We encourage you to create that will, which is your roadmap for the different ways you want your assets to pass. You've worked your whole life for everything that you have, and so you can make the decision of where it goes and how you want it to go once you've passed away.
The one thing that I give my first caveat is people will talk about, can I deed my kids onto my property? Can I do the quick and dirty? And that's why I call it the quick and dirty. I'm not a fan of it. That's a personal outlook on me. A lot of people, it works for their family, but every family is different. You'll hear us talk about different blended families and different, what happens when somebody divorces. That has an impact on everything. So what we've kind of determined from talking to people and from our experiences is, a will, a roadmap to your estate, really you should start that now if you haven't already. Stephanie has in her maroon folder, which is an awesome tool, the contact for the Worcester County Bar Association. So that's a group of more than 1,000 lawyers within Worcester County. It's a organization that we both belong to, that are all licensed attorneys, and they have specializations. So when you call, you get a person who will ask you questions, what specific you're looking for, and they will refer you to a lawyer. But then that's that extra level of accountability. So if they either don't return your call as quickly as you would like, or you find that they're not a good match for you, you can call back. So that's a great resource, because people are always saying, who do I call? Circle back to the quick and dirty. So it's great if you had everything lined up and everybody was the beneficiary, including your deed, but I'm not a fan of that, and I'm gonna give you a little caveat as to why is life change are constantly changing. The times are constantly changing. I mean, if you can't see this in the presidential cycle we're going through now, I don't know what rock you've crawled out from under. It's just, the world is insane, in my opinion, in the last 2 years coming out of COVID. And people are always kind of, inflation is there, people are trying to find ways around not paying for certain things and not, expending the little amount of money that they want to hang on to for emergencies and stuff like that. So they're kind of saying, well, let's do this quick and dirty, let's get out of here, let's, do whatever we need to do. And so they'll just do, and they'll go forward and say, I'm just gonna put my kid on the deed. So I'm going to add my kid and it should be no problem. Well, that being said what do you think a problem is if you add a kid to a deed? What if they're married? What if they get divorced? That's a marital asset. So when they get divorced at the probate and family court and your daughter's been added to your deed, and then all of a sudden they say, well, the future ex-son-in-law goes, well, my wife or soon-to-be ex-wife's on a $500,000 house in Bolton, I want a chunk of that. That's something you have to worry about. So the other thing is let's say everybody stays happily married. What if your grandkids are going to apply and they want to go to Tufts and it's $79,000 a year and you need to apply for financial aid? Well, that's now an asset. And that's going to skew the application for financial aid for a high-end university that your grandkids are going to go to. So these are things we want you to think about, so that when you start to talk to your family, your friends, whoever's in your life that you're going to talk to about these things, that you kind of bring up these ideas as far as what I want to do, and what we can emphasize repeatedly is communicate. If you have loved ones that are alive that you're working with, whether it's a spouse, whether it's a child, whether it's a sibling, niece, nephew, whoever is your confidant, communicate with them what you want. And then you're going to want to, bounce ideas off friends from the senior center, bounce ideas off friends from whoever you have coffee with in the morning, and find out what other people are doing and who they've talked to about these things. We can't, we bring that up repeatedly. You'll hear it, that theme always is communicate. So if you do have a will, take it out and look at it. Talk to your family about it so that there's no surprises. Make sure it's done right. Make sure you've looked at it the right way. Make sure your life hasn't changed. Those are some first key points.
Yeah, I think
it's in the car.
With reiterating Katie's points, kind of communicate and complexities. And so every family is different. Your situation is unique. It's your own. Your assets are your own. Your family dynamic is your own. And what we see, as Katie mentioned, is a lot of the fighting in the back end. And so hopefully we can have you thinking ahead so that you're not ending up with us in a legal battle. And that's where the complexities come in, is there's just so many layers to your family dynamic, and that's where working with an attorney is going to be best. We do encourage you to call that Worcester County Bar Association that Katie mentioned, or just talking to your friends at the senior center. You really want to feel comfortable with the attorney you're going to be working with, because you're going to be sharing a lot of your personal information, your finances, your family life, your dynamics there. And then, as Katie mentioned, communication is so key. If you leave with nothing else today, it's that you need to start thinking through your estate plan and how can you tell your loved ones about it and your family. It's not a conversation anybody wants to have, but that communication and that conversation can really stop you from feeling the pain on the back end in the court system, because you think no one's going to fight about money, and then there's money there, and people always fight about the assets. Someone always feels entitled to what somebody else had left, and they feel as though they could be wronged, and so that's where the legal battles ensue, and really the attorneys are the ones who win in that, because they're the ones that make the money in court. And so anything you can do to clean that up beforehand. We see a lot of people take their documents, and they ask us, what do I do with them? And Katie has a great book that we can talk about in a minute, but a lot of people will take their legal documents and they'll put them in a safe deposit box. We want to warn you against doing things like that, because you have to probate the estate to get access to the safe deposit box to even get to the will. So that's a whole backward complexity, but we encourage you to start preparing your documents and then get something like a safe from Walmart and put it in your office or your closet or somewhere safe in your house, and let your family know where those documents are. So much of what we see is families digging through paperwork on the back end, trying to figure out where you had bank accounts or what you did for this type of credit card payment, and letting your family know where they can find all those documents on the front end is hugely helpful.
So I'm so impressed. So we have, the people in TV land, we have 3 young women in the audience, and all 3 of them have notebooks, and they're taking copious notes.
Yeah.
So if I had been prepared, and it's sitting in my car, I just don't want to leave. I bought this book a couple years ago. After we had started talking about this, it made in how much information we have and how many stories we have of what people forget to put in their wills, or forget to say, or they come up with a question and say, well, what if I did this? I went on a super sleuth of the internet, Amazon, and I found this book, and then it kind of intrigued me, so I spent some hours looking at different books, both at Barnes & Nobles and at Amazon, and I ended up buying it. It cost me $16. It came 2 days in Prime. But it's a book, and if you just Google, like, how to plan my estate, and I can grab it after we complete this if you want to see. It's just one out of the 1,000 of options, but it's literally a fill-in-the-blank book, and it fills everything from, do I have a Facebook account and what's the password? Does it have a legacy feature? Do I have to have my family shut it down if I pass or I become sick so that people can't steal my identity? How many credit cards do I own? Does my Eversource or National Grid bill or my town taxes come directly out of my checking account, or is it set up, do I mail a check? You know, those are things that you can start planning for now, and having, you know, a Bible, if you will, or a notebook full of all, you can use the notebooks that you have, but this just gives you a little bit of a, oh, I didn't think of that type of thing, because we've had enough stories where people have shared with us that you don't think of that. So if you talk to people, you come up with that. So on a personal note, so my father passed away 22 years ago, and I say that because it should be a trigger. When you have, so my mother, losing her spouse, had to go through a lot of paperwork unexpectedly in her 50s. And so she went through all that, and thankfully they owned 99% of their things jointly, and everything just passed her automatically. There was one thing that remained outstanding, and it was some stock that my father had picked up somewhere, and it was only, I hate to sound cavalier, but it was worth about $4,000 at the time. And with all due respect, after everything we went through, I looked at my mother and I said, do we really need to deal with this? And we just let it go, so it's at fine mass money now. So I just don't want to deal with a lovely woman. I just don't want to deal with filing a probate to get that one thing out of probate jail, I guess I'm going to call it. So at the time, you know, it was one of those kind of choices we made as a family, because my mother didn't want to go through the whole process of filing a probate as a widow at 56. She just said, I just want everything passed automatically with the exception of this one stock. And it wasn't actually the hurdle of the probate court. It was the corporation that held the stock wanted us to go to a certain type of bank to get a certain type of medallion, which I had to look up and figure out what the heck that was. And we didn't have an account at that bank, so when I called the bank, they're like, we don't want to issue a medallion because you don't have an account with us. And it was just step after step that I looked at my mother and I was like, oh my God, do we have to do this? So my point of the story is things like that can be cumbersome for those that you leave behind, but also it was a trigger for my mother to start thinking about, oh, I have to change my estate plan. I'm now a single person. It took her 12 years. It took my mother 7 years to buy a headstone. So everybody does it differently. You know, I made her go on tax-free weekend, so that's how we accomplished that. But it takes, I did. That's how I did it. But you know, you go through these things, but you know, now it's been a decade since she changed her estate plan and everything has been done. So thankfully she's up to date on that. But those are the life things we're here to point out to you, whether you lose a spouse or you lose a child. If you have a will or a trust or anything that you've done some estate planning, if a monumental thing happens in your life, you yourself get divorced, you have to pull that out, because a will's no longer valid after you get divorced. So it's only worth the paper that you're gonna burn it on in the fire pit.
Yeah, your estate plan is fluid. It's a constantly evolving and changing thing because your life is evolving and changing. And so Katie mentioned divorces, a birth, a death, those type of major life.
Bankruptcy.
Yeah.
And anything can have an impact on a life estate plan.
And then we were mentioning the complexities of multiple families. So if you have a child that's married, what is that situation with their spouse? Those assets that you give your child now become marital assets. Should they get divorced, now it's part of the divorce. So thinking through those different layers on how you want things to pass. We can also suggest that if you do something like a will, you can leave people out of a will, and you can specify in language that you don't want somebody to receive something, and that's always important. If you really feel that way and feel strongly, then they don't have the grounds to contest it in court, or certainly fewer grounds, and you can pass assets the way you want them to pass by leaving somebody out of the will.
Another thing we like to mention, I had a near and dear friend, she lived to the great age of 94, but prior to her passing, she had actually worked at Sturbridge Village. She lived in Sutton and worked at Sturbridge Village till she was 89, God bless her. She wore the full costume, she did the whole thing. And when we threw her a 90th birthday at Sturbridge Village, before we went, she said to me, and she said, my great-granddaughter, who's just turned 18, great-granddaughter, is coming in with her family, with my granddaughter's family. They had a house in Harvard and a house in Alaska. And she said they're coming in from Alaska, and they're gonna stay in Harvard so they can come celebrate my birthday. I'd like to give her something to remember. What should I do? And I looked at her and I said, you talk about these diamond earrings that your son bought you eons ago. I've never seen you wear them. What's the intent? She's like, oh, I never thought of that. I said, give them to her now so that the other, grandchildren, great-grandchildren below her won't fight over it, or there's no other debacle, down the road. And so she gave them to her great-granddaughter on her own 90th birthday party. And it was a lovely, picture-perfect event and all that other stuff. And you just kind of look at it and say, what am I waiting for? Am I using this stuff? Those are things you may want to kind of consider when you're doing your estate planning and kind of thinking about, am I going to get hit by a bus next week? You don't know.
If you gift it in life, it's no longer part of your estate, so it's no longer an item that has to pass. So gift it, consider gifting it.
And then nobody can really necessarily fight about it. And that brings me back full circle to talk about communicate. I have a great aunt that passed away in February of 2020 at 99 years old. And you would think that her children would be mature at 70 years old. Think again. After she passed, the wives of her sons, which is where it gets fun with family, started asking her daughter, who was the eldest child, who was the executor of her estate, where some of her antique jewelry was. At which point the daughter said, well, she got rid of that stuff and gave it to nieces and nephews and various other people over the course of the last decade. She was very pragmatic. She planned everything. And these daughter-in-laws, who are 70-year-old women, weren't believing anybody. And it was just kind of like, well, no, there's value in that, and we need that money. And I feel like saying at 70, and these people are not in need of money, I'm just gonna say it. You look at it and say, wow, this is how catty and what we get to at the end. But that's the stories we see. You don't hear the easy ones. I mean, we come to these things and people thankfully share back with us, but we don't hear the easy ones for the most part. We hear the hard ones. Which lets me go to one of my other stories. We were in Auburn last spring, and a gentleman, he was a veteran, never married, no children, decided to add his sister to his deed. He thought it would be easier. In case something happens, they had joint tenancy with right of survivorship. So the definitions are in the folders I left with you guys. So if one dies, the other one automatically gets it. All you have to do is go to the Registry of Deeds and record a death certificate. And that's just proof that one of the owners has passed, and then it goes to the remainderment. And you avoid probate. Well, the problem is they're both still alive, and the sister decided unilaterally that she didn't want to own this with him anymore, but she could use the money. So she went to the probate court and filed a petition to partition to force the sale of the house that he paid for, and he only put her on it for purposes of avoiding probate. So you come back to my full circle of the quick and dirty deed can bite you in the behind. So he came and he was very kind to share that story with us, and he was going through the drama of that. He had to pay for a lawyer to defend the rights in his house that he owned, that he thought he was doing her a solid because he had no children, that was the only living relative in his family, and while he was still living, she was bouncing him out and stealing his equity. So those are the things that we have you say. I don't mean to scare you, but these are real world things that happen that you have to kind of say, oh geez, could somebody turn on this? Or does this really happen? Is my life that, do I have blinders on? Am I happy-go-lucky? And you kind of want to, eyes wide open, see what's going on and make a plan,
Have we sparked any thoughts or
Any
questions?
thoughts or
We'd love to
questions,
hear from you,
stories?
see if we can help.
I do, adding some
Sure.
to your deed.
Okay.
So the house, my house came before my marriage, so my house is only in my name.
Okay.
If
But
I trust my husband, should I add his name to the
How many years have you been married?
19?
Okay, so it's already a marital asset, even though you owned it before, because of the years, there would be something said for that, because I'm assuming you let him sleep under the same roof.
Yeah, he does, yeah.
He stays there. So he could prove that he's been contributing to the household expenses and all of that for 19 years. You could add him. I mean, all jokes aside, I built my house with my husband before I was married. And initially, it was in his name only, and we then we got married, and then we waited another 5 years, and then we added my name to the deed. We didn't do it quite, we did it in kind of bits and pieces, and we still joke about that, because he goes, what am I gonna do if we get divorced? I'm screwed because I married a lawyer, but anyway, I think you'd probably be fine with a spouse. I mean, that makes it a little bit easier. Should have something happen to one or both, however that works.
Okay.
You mentioned the T word, trust. Did you mention trust or no? No, you didn't. Just deeds. Okay, good.
So,
You're gonna dodge that bullet today. No, I'm just kidding. I don't mind talking about trust.
Could you talk a little more about trust?
Sure. So there's 3 big types of trusts. There is a realty trust, which involves just basically putting a piece of real estate into the trust, and it's basically just it's a bare bones trust, and it doesn't give you a lot of coverage for anything if you're doing it for Medicare, mass health planning, or anything like that. It basically transfers ownership out of you individually into a separate entity, and that's for purposes of people suing you. So if you leave here and you drive to Hudson because you're going to the mall to have something at Panera, and you have a car accident, you kill somebody and they sue you, you don't own your home because the trust owns it. So it gives you a little bit of a layer of insulation. But that's kind of like the most simple form of trust. The next one is what's called a revocable trust. Everybody starts getting the nods because they've heard about different trust types if you talk to your Shine representative or anything like that at the senior center. A revocable trust is a little bit beefier, but not the granddaddy, which is the irrevocable trust. So a revocable means you can revoke it, you can change it. You're still putting things into a different name, you're removing it from your name individually, and you're pouring it into something that's a separate legal entity or a trust. But it's a little bit more flexible if you do a revocable trust. A lot of people find that that's a good baby step if you can afford to kind of start that way when you're a little bit younger, and gives you a little bit more flexibility. I'm 50 years old. I would consider I own 2 homes. I own one in Massachusetts, one in Florida. I would consider doing revocable trusts at this stage in my life, knock on wood. I'm healthy and I'm only 50. So I would think that would be my baby steps of estate planning, because I don't know I'm going to stay in the house in Worcester. I don't know if I'll stay there once I retire in a decade or more. So I don't know. But that would be a layer of protection should something happen. But if you do an irrevocable trust and you are looking for a lawyer, you're going to call the Bar Association, you might want to use that magic word that you want to ask about an irrevocable or non-revocable trust. A lot of lawyers are scared of them because once you put them in there, you really can't undo them. They're there. So it's a more permanent, it's got a little bit more heft to it, but that's the one that's going to help you get around the nursing home bills and the Medicare bills out of the gate. A active reminder, the look back period remains at 60 months. That doesn't mean that Mass Health and Medicare doesn't look back further. They do, they terrorize people a little bit, but that's their right because they're holding the money. They're holding the payments to the nursing homes type of thing. So they can be difficult. The rule has always been 60 months, but I've had friends whose parents have gone into nursing homes and out of irrevocable trusts, and they would release the trust at month number 64 and put my friend, her mother-in-law, in a nursing home with her husband. And it was 64 months after they did the trust. They sold the house in Bedford, Mass, not far from here, and they were able to pay for the first 2.5 years out of pocket cash. But once they started the Mass Health Medicare application for payments of the thing, they started questioning the trust. And eventually it worked itself out, and Mass Health Medicaid is paying for the woman in a very beautiful facility. By the way, she's having the time of her life. She's very social. But it was a long, drawn-out process because they made them do the dates.
Mhm.
It does happen, but long story short, they're now successfully on Mass Health Medicare because they did the trust right and they waited the right time frames. Does that help you a little bit with the bare bone basics?
Mhm. Yeah.
Great, yeah. So a lot of people, lawyers in particular, sometimes get a little nervous about irrevocable trusts. So when you call or you ask around, you're gonna wanna do a heavy-duty estate planning attorney is kind of what you're looking for, somebody that's all they do. I wouldn't recommend going to somebody that has listed on their door 20,000 things like I do this, I do that, you know, I will help you with your bankruptcy, I will help you with your adoption, I will help you with your immigration green card status, and I'll write your trust, because that's somebody who might be doing a few too many things. Personal opinion. You may want to hone in on somebody that they spend 40 hours a week devising something of that caliber that's going to, you know, be in your best interest in that kind of heft instead of just stealing a sample from another lawyer type of thing. So be mindful of that. Those are the questions you should ask. Another thing I like to say is when you shop lawyers, if you don't like them, go somewhere else. It's like having a doctor. If you go and you get an opinion and you're like, yeah, I don't think so, and you go get a second opinion, same thing with lawyers. Absolutely, you're gonna share with them some personal information, your financial information, your family dynamic, your thoughts and your desires, and it's kind of, you get into the nitty-gritty personal. Like, I like this kid but not that kid, or I don't like their spouse, how do I deal with that?
And always going prepared is helpful. That's you're starting by coming here or watching this presentation and just starting to think through where assets have passed, how they've passed, if you want to trust, if you don't. That helps save you time on that front end in your initial consultations, and as you start to work with the attorney, it keeps it cleaner and more efficient to know some of what you want and then have the questions prepared.
So maybe you can tell them that you have to have the original document, make sure you hang on to that.
Definitely want an original will. We see a lot of that. So if you're going to probate an estate, you need to come with the original will. Very often, I had mentioned before, you know, people will put it in a safe deposit box or they don't tell their family members where it is. We see a lot of fights over a copy of a will. Somebody believes their mom gave them a copy, this would be the most accurate will. The court can't do much with that. We need the original will, so it has to be signed, witnessed by 2 people, and notarized. That's what makes it a valid will for us in the court. And once we have that original, that's part of processing your estate, but making sure you have that, know where it is. We see sometimes people will leave it with their attorney. Katie can describe that a lot of attorneys will charge you on the front end to process that will, hold on to it so that they can also get the clientele on the back end. And really you should hold on to your own will. That's what I would suggest, is make sure you have it, make sure you have it locked up and somewhere safe. Because then you'll know where it is, and having that conversation with your loved ones as well to tell them where they can find it.
We get a lot of stories in both our offices. People will call and say, my attorney's either retired, died, whatever, and there was no estate plan for his or her practice. And believe it or not, you can, as a lawyer, devise an estate plan for your practice. The what if, you know, like I just got back from Florida on Sunday. What if I got stuck in a hurricane down there? What would have happened to my files? Who has access to them? Where are they located? All of the above. So I have that laid out, and I have people that can step in and be available to sift through my stuff and know where the keys are to the filing cabinets that are locked, so to speak. But not every lawyer thinks to do that. And so you really kind of want to ask those questions, and that's why in doing these last couple of years, I've kind of come around the bend and said, you know, you really, I was kind of pro this anyway, but I kind of push it a little bit more, is if you have, you know, you're welcome to share copies with your family, but make sure you keep that original somewhere where somebody that you trust can get to it, because, you know, if somebody says, oh, it's gone, but it's not really gone, you've got that issue as well. So it's kind of an odd dynamic, but you really need that original one to probate, otherwise it becomes a mess and it's a he said, she said with a lot of finger pointing, and the court has no idea.
And we've mentioned that, you know, a good estate plan is changing, so it's reasonable that there would be multiple copies of wills. Obviously, we want the newest, most recent, and what Katie mentioned might give you some thought for whether you want to work with an attorney in a law firm or an attorney who has a solo practice, but that is a personal preference. But another element to think of when you're selecting an attorney that you'd want to work with, and how they handle their documents and where they keep them.
So I had a call from a woman last spring down in Milford, which is also in our district, and Milford, Mass, and she had hired a lawyer in about 2015 to put her house into a bare bones realty trust. And in Massachusetts, we do not require that you record the trust, just the deed putting it in the trust. So she paid all this money, and that was part of her estate plan. It was a will and then a separate realty trust for the house, and that was the plan that her and her lawyer had devised. And then fast forward 2018, he retired. And he had been in a firm, or of counsel in a firm, but there was some other lawyers involved. But he and his wife moved to Florida, Sarasota, and then he died, 2021. And so this woman was now getting ready to sell her house in 2024, and the buyer's attorney was looking for the actual trust document because the deed wasn't enough to give information to pass title cleanly. And so we have a clear title standard in Massachusetts. So she was looking to check, you know, kind of ferret out information, was doing her own kind of investigation, so she called the registry. So I prompted me to ask her some questions, and I was like, as I was talking to her, I was doing a Google search, and I'm like, yeah, he died in 2021, his wife's still alive. She's like, oh yeah, we reached out and found her, and her estate plan's missing too. Apparently he was supposed to leave everything at the law firm in Milford. They couldn't find anything. So she was not one of his only clients. All of his clients' paperwork was missing. And all of this happened, and it all died with him. And so this woman was now having to reinvent the wheel and recreate things and go back and do all this stuff in spring of 2024 after she paid for it all in 2015, because she just didn't know, and she left stuff there and didn't ask the questions and say, well, you know, where is my trust if it's not on record? And some people don't want to record trust, and I get that. If you're a billionaire sitting here, first of all, I'd be shocked, but I'd be flattered. Second of all, you know, these people that come in and they're not recording trust, sometimes I'm kind of like, what are you trying to hide? I mean, some people do it, domestic violence, various other things, but more often than not, people are like, oh, well, somebody told me that, you know, they can't chase you for certain things, and I'm like, really? Because Uncle Sam is going to find you, and somebody's going to charge you taxes. What are the two things in life that always exist? Death and taxes. So I'm a fan of having a trust recorded, because it as a title attorney and real estate attorney, it makes our jobs 1,000 times easier, because then you don't have to go and reinvent stuff. But some lawyers, if you go back, going full circle, you go to a lawyer that only does a little bit of this, a little bit of that, and they're like, oh, no, you're right, you don't want to put that information out in the World Wide Web, and it's a public record, and yada yada. Then you run into problems down the road because you didn't ask the question of, well, what if? What if? And those are the things you should constantly just ask, what if? That's kind of what I hope that you gain from this when you interview a lawyer. Any other questions or comments? I don't want to be boring. So a new service we have at the it's been recycled. It had fallen to the wayside because of software issues. But at the Worcester Registry of Deeds, if you're a homeowner, we have what's called a consumer notification service. There should be a handout in there. If not, I have some more. And it's a free online thing. A lot of times people will tell me, especially this time of a presidential cycle, you'll see if you're a TV watcher, you'll see things like LifeLock or Home Key Title and these services that will talk about deed fraud and scare you and say somebody's gonna steal your home. Does it happen? Yes, just happened a month ago in Concord.
Yeah.
Concord, yeah. So somebody saw it on news, Cheryl Fee and Doc, yeah. So does it happen? People attempt to do it, but I'm here to tell you, they can't steal your home because they can't steal it because you own it still. So they just make it a holy mess for you, similar to somebody stealing your social security number and opening a credit card. It's on the same lines, it just seems so much bigger because it's your home. So the story, for those of you who didn't follow it in the news, was a couple had lived in Massachusetts and decided when they retired they were going to return to Massachusetts, but they've been living in South Carolina. He was practicing medicine and I don't know what his wife was doing, but they owned a parcel of land in a neighborhood in Concord, and their ultimate goal was in retirement to build a home and retire in Massachusetts. Well, all of a sudden this June, they didn't get their quarterly tax bill. So that prompted them to call the town tax collector in Concord and say, hey, we didn't get our tax bill. So they were hyper aware of things that they'd been paying the taxes, vigilantly. And they said, you don't own it anymore. So they were like, what are you talking about? Long story short is somebody created fake ID. They saw there was a vacant lot. It was worth about $1.2 million, but it sold for about $500,000. That's a huge red flag. It sold with a fake ID out of South Carolina with a fake passport, and the lawyers, Massachusetts lawyers, missed it because it had the same picture. I don't know about you, but the RMV picture is not the one I use in my passport because they don't let you do that. So things like that it was kind of interesting that it just kind of went to the wayside. It was also a deed that was notarized in Texas with a South Carolina license. Now we know people are moving around a little bit, but it didn't trigger any questions. The couple that bought it was a bona fide third-party purchaser on the tail end. They started to build a house. So they're the ones, that's the second hit of the victim. So the first victim now has to clean up this mess, who owns the property. The second victim has now taken out money or used money to start to build their dream home, which they do not own. They own the wood that's in there, but but they don't own the land. So we have what's called a consumer notification service. It's free for anybody that owns property. You go to our webpage and you sign up for it, and you list your legal name that's on your documents, or any variation if you want of, and then also the properties that you own. If you own, you can list up to 3 per sign up function. And I own my house, and then independently we own the lots next to us, but they're not in one deed together. They're 2 separate deeds. So when I signed up for consumer notification, I have 2 properties listed. And so if anybody tries to record something, I immediately get an email. Now, it's after the fact, but that's the same service LifeLock and anybody else will tell you. So those are things that nobody knows until it's on record. We were up in Gardner, Mass. Earlier in the spring, and there was an angry gentleman. I think he was victim of fraud in some capacity, and he's like, you should be checking signatures at the registry. And I'm like, how do I know how you sign your name? But that's why we do things with notaries and all that other stuff. And I will say, it's very interesting. I went to a public records industry association event in Cleveland this August, and other states like California and Oklahoma and various other places, they actually list all their notary publics on their webpage at their Secretary of State's office and identify them and have the ability to look up what their signatures looks like. So they have a lot more fraud than we do. I gotta be honest, Bill Galvin keeps it close. And you cannot get a copy of what a notary signature looks like or anything unless you, or certain information, unless you know how to dig deep, and he won't release it. So it's kind of an interesting dynamic, but Massachusetts, as puritanical as we is, we kind of keep some of our stuff held in pretty tight. So our deed fraud's really low, which is pretty great. But that story was kind of a eye-opener one in the last few weeks for anybody that saw it online. It's kind of interesting. So, any other questions?
Anything else?
No?
We both provided information, our contact information in our folders.
Yeah.
I have a link to our virtual registry, so should you have any questions that come up, you can always reach out to us and call us if you have access to a computer or your phone. And then I think we both have emails in there,
Yeah.
but certainly if questions arise, feel free to reach out and
Yep.
we're happy to help.
We have customer service teams if we're not in the office, if we're out doing these things. I know I do that, and I know Stephanie does, they'll immediately answer the phone or emails or anything and be able to answer questions or direct you to the right person or tell you when we'll be back to answer any questions. But we're out here, we're your public servants. Thank you.
All right, thank you.
Yeah.